According to the Fair Labor Standard Act 1938, a lawsuit shall be brought against employers under the FLSA Act. However, per requirements are set in order to enforce Section 29 U.S.C. 216b. The section provides a clear direction to the parties involved in the enforcement of 216b. Any employer who violates the provisions of Section 206 or Section 207 of this title shall be liable to the employee or employees affected in the amount of their unpaid minimum wages or their unpaid overtime compensation, as the case may be, and in an additional equal amount as liquidated damages. The condition pursues to find the violation prior to the enforcement, and finding violation must be identified by the Department of Labor, who is responsible to conduct the audits in order to find violations of Section 29 U.S.C. 206, 207, and 255. If the Department of Labor finds violations against any employers, the DOL can move to enforce 29 U.S.C. 216b to the Department of Justice. After finding the violation against an employer by the Department of Labor shall send memos to each worker involved in order to inform them about the violation and the opportunity to enforce the said violation against the employer. The letter shall instruct the workers to sign the consent and take an oath that shall be authorized by the court to enforce Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216. The Department of Labor has to coordinate to comply with the summons and complaints and cover sheet, JS-44, to file it to the federal court under Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216 to enforce the Social Security benefit under the federal law called FICA. Under the Section 29 U.S.C. 216a, any person who willfully violates any of the provisions of Section 215 of this title shall, upon conviction thereof, be subject to a fine of not more than $10,000, or to the imprisonment for not more than 6 months, or both. No person shall be imprisoned under this subsection except for an offense committed after the conviction of such person for a prior offense under this subsection. Employers who improperly classified nurses as independent contractors, and as a result, employers failed and refused to pay their employer's share of the Federal Insurance Contribution Act, FICA, taxes on each nurse's gross wages, and accordingly plaintiffs were required to pay the same. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses, employers were unjustly enriched. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses and failure and refusal to pay nurses for travel time between consecutive assignments, they exercised dominion over and appropriated such funds for their own use and benefit, thereby depriving nurses of the rights and benefits thereto. Accordingly, employers are guilty of conversion. As a proximate result of employers' conduct, as alleged herein, nurses suffer damages and are entitled to an award of compensatory and consequential damages. All other similarly situated employees are also entitled to damages in the form of uncompensated overtime wages, liquidated damages, attorney's fees, and other damages so as to preclude employers' unjust enrichment. Pursuant to Section 216b, attached hereto and filed with this complaint as Exhibits A through late, the consent to become party nurses executed by each nurse.